I've seen inventors lose millions of dollars, not because their ideas were bad, but because of mistakes they made before they ever successfully file a patent application. Today, I'm breaking down the 7 most expensive patent mistakes inventors make, the ones that quietly destroy your leverage, your ownership, and your company's valuation. If we haven't met yet, I'm Mark Trenner, a patent attorney, and I've been practicing for over 25 years. Back in 2004, I founded my own law firm because I wanted to work directly with solo inventors and startups, meaning that when you work with my law firm, you're working directly with me, not a junior associate, not a patent agent. Before I started that law firm, I spent 4 years as in-house senior patent counsel for the National Laboratory of the Rockies. There, I manage patent portfolios, handling tech transfer, and negotiating licensing deals between startups and small businesses and the US government. I've seen 7-figure mistakes firsthand across all types of industries, and I want to make sure that you don't make the same mistakes. So let's talk now about how you can avoid making those mistakes. Let's start with mistake number 1, public disclosure before filing. I once had an inventor show off his prototype at a major trade event. The market interest was massive, but within weeks, a competitor copied the concept. Because he spoke publicly about it before getting a patent application on file, it created a major prior issue that jeopardized his rights. In the US, you have a 1-year grace period, but internationally, public disclosure instantly destroys your patent rights in most countries. So file first, talk later. Mistake number 2, using cheap online patent mills. An inventor came to me after using a cut rate automated online filing service. Sure, he had patent pending status, but the claims were written so poorly and generically that a competitor could easily have designed right around it. Cheap upfront legal fees almost always cost more later. In patent law, the specific claims matter far more than the official paperwork. Mistake number 3, filing before you validate market demand. I've seen entrepreneurs spend over $20,000 protecting an idea before they ever spoke to a single customer. Intellectual property protects the value, but it doesn't create the value. Validate your demand before you sink your entire budget into heavy filing fees. Mistake number 4, missing inventor assignment agreements. A startup client of mine had a co-founder leave the company early on. They also had a third-party contractor who helped write code. When an investor came along for due diligence, they realized neither the co-founder nor the contractor had signed ownership assignments over to the company. This lack of due diligence up front nearly killed a 7-figure deal. Ownership confusion kills valuations. Always get ownership figured out in the beginning. Then get your assignment agreement signed early and legally lock those down. Mistake number 5. Mistake number 5 is not documenting your invention's conception. I watched 2 independent inventors get dragged into a messy dispute over who actually thought of the idea, but because they lacked any sort of lab notebooks, sketches, or clear email records, just that threat of litigation could have ended their company. Actual litigation, that would have become an incredibly expensive nightmare. Always document the evolution of your invention. Even so it's first to file, there's times when you need to be able to show who invented what and when. Save your sketches, emails, and version histories. You need to be able to prove that you're the inventor. Mistake number 6. Thinking a provisional patent application means you are fully protected. Many inventors file a provisional application, see the words patent pending, and assume that they can sit back and do nothing. I've seen inventors lose incredible leverage in negotiations because they failed to move forward with the product. And worse, I've talked with inventors who lost all their rights to their invention because they let the 1-year provisional window expire without converting it over to a non-provisional application. A provisional patent application is just a temporary placeholder. It buys you exactly 12 months of time, not market share and not permanent security. All right, finally, mistake number 7, missing international deadlines. An inventor told me once that they had successfully filed their US patent, but a few years later, a massive manufacturing opportunity popped up in Europe and Asia. Unfortunately, their foreign filing window had already slammed shut. They thought they could do that at any time. But international patent timing is completely unforgiving. Your global strategy needs to be planned early, not as an afterthought. Which one of these 7 mistakes surprised you the most? Let me know in the comments below. And remember, protecting your hard work requires strategy, foresight, and a direct partnership with legal counsel who knows the ropes. If you have an invention you need to protect, click the link in the description below and schedule a strategy session with me directly. And don't forget to like this video and subscribe for more weekly legal strategies to protect your business. Thanks for watching, and I'll see you in the next video.